Greetings everyone, I am Rahul Mishra. Today we will look into the topic confiscation and seizure of media. So, the first question is, what is confiscation? Confiscation is a legal form of seizure by government or other public authority. It usually is for a limited period, which is like until the case for which the evidence has been confiscated has been closed. The authority remains with the owner itself. It may occur legally when the government seizes property used in illegal practices, such as a boat used to smuggle illegal drugs. Confiscation may occur without an arrest of a person because it is seen as an arrest of property rather than a person, and the necessity of finding a party guilty is not required in all cases. Now, coming to seizure. What is seizure? Seizure is a procedure used in many civil law and common law legal systems by which police or other authorities and their agents who, suspecting that a crime has been committed, confiscate any relevant evidence found in connection to the crime. In criminal law, a seizure is the forcible taking of property by a government law enforcement official from a person who is suspected of violating or is known to have violated the law. A search warrant usually must be presented to the person before his property is seized, unless the circumstances of the seizure justify a warrantless search and seizure. For example, for a murder investigation, police do not need a search warrant to search and seize the evidence at the crime scene. In case of cybercrime, seizure of computers and related peripherals is not always the practical approach without preliminary investigation. A cybercrime investigator has to decide whether it is prudent to seize or to complete the investigation at the scene. Seizing and carrying out the investigation off-site would involve proper packaging and transporting of the computers and accessories, reassembling them at the laboratory and recreating the network or configuration. This can be a complex and sensitive issue, and hence the cybercrime investigator must bear the following in mind before taking the decision on whether to confiscate and then investigate, or whether to investigate on site. Volume of evidence. Cybercrime investigator must calculate whether it would be practical and feasible to confiscate, package, transport and then reassemble the confiscated material. For example, if a distributed denial of service attack has taken place, then it would not be possible to carry the computers found at the scene. Technical issues. If the situation is such that the computers have to be sent to an outstation expert for examination, then confiscation would become necessary. Infrastructure issues. If the situation is such that the cybercrime investigator does not possess the relevant tools for carrying out an on-site investigation, then it is prudent to confiscate the computers and carry out an extensive examination at the place where the infrastructure is present. Attempting to examine the evidence without all the required tools, software and hardware can lead to irretrievable loss of data. Time available. At times it is essential to carry out an urgent investigation. Example, while tracking down a terrorist organization that is likely to carry out a major attack. In such situations, there may not be enough time to confiscate and then investigate. It becomes imperative to examine the evidence with whatever tools and expertise are available. Indian jurisprudence on privacy is a wide departure from that of the USA. Though it is difficult to strictly compartmentalize the many facets of the right to privacy, there is no express or implicit mention of such a right in the Indian Constitution. Section 93 here provides for the general procedure of search. Section 93 allows for a magistrate to issue a warrant for the search of any document or thing, including a warrant for general search of an area where it believes it is required for the purpose of investigation. The particularity of the search warrant is not a requirement under section 93(2), and hence a warrant may be for general or roving search of a place. Section 100, which further provides for the search of a closed place, including certain safeguards such as the presence of witnesses and the requirement of a warrant before a police officer may be allowed ingress into the closed place. Regarding digital privacy in particular, framed under section 43A of the Information Technology Act, where any government agency may, for the prevention, detection, investigation, prosecution and punishment of offences, obtain any personal data from an intermediate body corporate which stores any data. The rules framed for such investigation of digital evidence therefore do not inspire much confidence where safeguarding privacy is concerned. We will do a small case study here. Ganias was an accountant, and in 2003 the government suspected two of his clients of fraud. During the investigation, agents obtained a warrant to search Gania's files, including his computers, for data related to the business, financial and accounting operations of the two targets. Ganias was not suspected of any wrongdoing at the time. In executing the warrant, the agents made exact copies or mirror images of 3 hard drives belonging to Ganias, including wholly unrelated personal files and files of other clients. Back at the lab, investigators segregated the responsive data from the unresponsive data, but kept the original copies. 2 years later, investigators asserted that they had independent probable cause to believe that Ganias was engaged in tax related crimes, and as a result they obtained a second warrant in 2006 to search the mirror images retained from 2003, uncovering evidence that led to Ganias' conviction. On appeal, Ganias argued that retention of the mirror images for more than 2 years, including the caches of non-responsive data, violated the 4th Amendment's prohibition on unreasonable seizures. A unanimous Second Circuit appeal agreed, suppressing the evidence from Gania's hard drive and vacating his conviction. In an unusual move, the Second Circuit Board opted to hear the case en banc despite no request from either party, and in yet another twist, the court declined to rule on whether retention of the forensics mirror violates the 4th Amendment, ultimately refusing to suppress any evidence based on the good faith exception to the exclusionary rule. But in the process, the court also issued more than 20 pages of dicta on digital searches and seizures designed to influence lower courts for future cases. Coming to the next topic, which is what to confiscate, what are the parts which we can confiscate. Confiscating hardware. It is absolutely essential to confiscate the entire contents of the system cabinet without separating them. Confiscating storage media. Storage media such as hard drives, CD-ROMs, USB drives and so on can prove to be a valuable source of evidence. Not only may they contain incriminating evidence, but also software, device drivers and other programs necessary for the investigation. Confiscating peripherals. Some software does not function properly if the necessary peripherals, example printers, are not connected. Hence, it may be necessary to confiscate all the relevant peripheral devices like printers, scanners and so on. Confiscating documentation. Even experts need documentation while examining and operating the various types of hardware and software available. Transportation and storage of digital evidence should be thoroughly documented. When packing digital evidence for transportation, the first responder should ensure that all digital evidence collected is properly documented, labeled, marked, photographed, video recorded or sketched and inventoried before it is packed. All connections and connected devices should be labeled for easy reconfiguration of the system later. Pack all digital evidence in anti-static packaging. Only paper bags and envelopes, cardboard boxes and anti-static containers should be used for packaging digital evidence. Plastic materials should not be used when collecting digital evidence because plastic can produce or convey static electricity and allow humidity and condensation to develop, which may damage or destroy the evidence. Ensure that all digital evidence is packaged in a manner that will prevent it from being bent, scratched or otherwise deformed. Label all containers used to package and store digital evidence clearly and properly. Leave cellular, mobile or smartphone in the power state on or off in which they were found. Package mobile or smartphones in signal blocking material such as Faraday isolation bags or aluminum foil to prevent data messages from being sent or received by the devices. First responders should be aware that if inappropriately packaged or removed from shielded packaging, the device may be able to send and receive data messages if in range of a communication signal. Collect or power supplies and adapters from all electronic devices shield. Transportation procedures. When transporting digital evidence, the first responder should keep digital evidence away from magnetic fields such as those produced by radio transmitters, speaker magnets and magnetic mount emergency lights. Other potential hazards that the first responder should be aware of include seat heaters and many devices or material that can produce static electricity. Avoid keeping digital evidence in a vehicle for prolonged periods of time. Heat, cold and humidity can damage or destroy digital evidence. Ensure that computers and electronic devices are packaged and secured during transportation to prevent damage from shock and vibration. Document the transportation of the digital evidence and maintain the chain of custody on all evidence transported. Storage procedures. When storing digital evidence, the first responder should ensure that the digital evidence is stored in a secure, climate controlled environment or a location that is not subject to extreme temperature or humidity. Ensure that the digital evidence is not exposed to magnetic fields, moisture, dust, vibration or any other elements that may damage or destroy it. The chain of custody in digital forensics can also be referred to as the forensic link or the paper trail of electronic evidence. It documents each person who handled the evidence, the date and time it was collected or transferred and the purpose for transfer. It is important to maintain the chain of custody to preserve the integrity of the evidence and to prevent it from contamination, which may alter the state of evidence. If not preserved, the evidence presented in court might be challenged and ruled inadmissible. Importance to the examiner. Suppose that as the examiner you obtain metadata for a piece of evidence. However, you are unable to extract meaningful information from it. The fact that there is no meaningful information within the metadata does not mean that the evidence is insufficient. The chain of custody in the case helps show where the possible evidence might lie, where it came from, who created it and the type of equipment that was used. In order to ensure that the chain of custody is as authentic as possible, a series of steps must be followed. It is important to note that the more information a forensic expert obtains concerning the evidence at hand, the more authentic is the created chain of custody. Due to this, it is important to obtain administrator information about the evidence. For instance, the administrative log, date and file information and who accessed the files. The conclusion: when the investigator is at a crime scene, he or she needs to take a lot of things into consideration. For example, the jurisdiction, the law, the power to confiscate or seize, the reasons required, then comes the type and quantity or size of evidence. So, it becomes quite difficult a lot of times to confiscate or seize evidences.